Hello, people. Today is Monday, January 27, 2020. When I was in prison, I started studying law. And as Martin Luther King put it when he was in the Birmingham jail, in the context of speaking on his critics, he stated that a lot of mail would come across his desk and that if he would respond to each piece of mail that criticizing him, he could not have time to get any other work done, constructive work done. And then so he also stated or either concluded that what else does a person have to do that is confined in jail other than to write long letters, think long thoughts, and meditate and things like that. So I like to test something with you. I've gone 29 days with no food and no water, and I could build a case surrounding this in terms of God's laws of justification. God's laws of justification. Not so. When I was in prison in hell, which is not 6 feet in the ground. You do not dig 6 feet in the ground to get to hell. Hell in Texas is at P.O. Box 99, Huntsville, Texas, which is the Texas Department of Criminal Justice Institutional Division. Make my point. The United States Constitution, Article 6, Clause 2, provides that this Constitution and the laws and treaties which shall be, future tense, made in pursuance thereof shall be the supreme law of the land. And the judges, whether they be state or federal, of every state shall be bound thereby. And anything in the constitutional laws of any state to the contrary is void, or call it null, but I never say void and null because these words have the same meaning. Okay, so the United States Constitution, please read it. Article 6, Clause 2 provides that it is the supreme law of the land. Therefore, despite what John Hamilton, George Washington, John Adams, Thomas Jefferson, James Madison, Andrew Jackson, John Quincy Adams, Martin Van Buren, William Henry Harrison, John Tyler, James K. Polk, Zachary Taylor, Miller Fillmore, James Buchanan, Abraham Lincoln, Andrew Johnson. Maybe I missed one. Believe, feel, or think. We can only go by what we know. I wish people quit talking about they believe in Jesus or they believe in God. You got to know God. I don't give a doggone, and you should not give a doggone about what people believe, feel, think. Believe, feel, and think. People quick to tell you what they feel. I don't believe, I don't think. Who cares about your opinions? Now, this word called interpret. Let's go back to the late and former Chief Justice of the United States, John Marshall. Pay close attention to what he said. The judiciary do not interpret the Constitution and the laws. No, read it. You will probably read of him saying interpret, but read the words, please. What a court does is declare the law. Courts, nor can the federal courts or the judiciary declare an act of Congress is void. They can't do that, and they've been getting away with that. You can't do that. What the justices of the United States, federal judges, can do of the courts, they can declare the Constitution or the laws of a state not constitutional. No such thing as unconstitutional. Non-constitutional. They can declare that, but they cannot declare acts of Congress provision in the federal Constitution as not constitutional. And I don't think, and I know they never do say that. Well, perhaps they did not declare one provision of the federal Constitution as unconstitutional. I think they just repealed that, dealing with alcohol, something like that. But now my point is this. It doesn't matter what John Hamilton or anyone else said about high crimes and misdemeanors. The Constitution itself, which is the supreme law of the land, and the statutes and the treaties, that is the law. We don't go around interpreting what the framers meant. We only go by what is written. That's why judges declare the law. Now, I can't, I'm in a hurry. So, for example, I think I've given this example before. Sometimes we do come upon something such as looking over his shoulder. Marvin Gaye or Bill Clinton or Donald Trump saw the Empire State Building. And according to my English grammar books, we call that a Dagling modifier, because this ambiguous, because we know, looking over his shoulder, the Empire State Building was not looking over anyone's shoulder. The person was looking over his or her shoulder and saw the Empire State Building. And then, a court might interpret that. I should have prepared for this here to make the argument. Courts do not interpret law. Courts adjudicate the facts that are not in dispute and render a decision. And they do other things too. But when it comes to the law is what it is. If we don't like the law, we can amend our Constitution, or we can Congress, the court, judges can declare that render an opinion about the impropriety of a law, but they have, the courts, no power to overrule, declare void an act of Congress. They don't have. They can declare that the law is in conflict with the Constitution of the United States, but the federal courts have no authority or jurisdiction. The courts have no jurisdiction, therefore her justices or judges have no authority to declare the law void, which means don't even worry about that. No, they can't do that. And judges, you need to stop doing that. Not the acts of Congress. You can't do that. You can do that for the acts of the states, but not of Congress. Now, having said that, the Constitution, Article 3, or rather Article 2, Section 8, I'm thinking. So, because I'm thinking, don't hold me to that. It's just my opinion. Declares that the president, upon conviction, shall mandatory be removed for only high crimes and misdemeanors such as bribery and treason and those of the like. The fact that John Hamilton and any other framer of the Constitution was around and knew what they were debating about and have insight on what was going on, that's nice. That does help us get some understanding of how things work, inform our understanding, but that does not resolve anything. We can only go on what John chapter 16 verse 8 or 7 to 15 states. That's the Bible. We can only go on what Article 2, Section 8 of the United States Constitution provides. So since the Constitution says that these two provisions work together, Article 6, Clause 2 makes it very clear to you that this Constitution, not what the framers and James Madison and John Monroe believe, feel, and think, that does not count. That's why, and nor do we commit we need to know. President Trump has a right to know also what conduct to avoid so that he and any other president cannot be, so they can avoid conduct that's impeachable. You can't let me go there, because well, that's what due process comes in. Protection. I cannot commit a crime and do an act and then later be told, oh, that's unlawful. I need to know it ahead of time. And that's what also I want to point out. So somebody needs to come and put all what I'm saying together, because I ain't have no time to put everything in chronological order, because I got something going on. What was I going to? I had lost the thought. Hopefully it'll come back. But yeah. So it's what the law. It's what the law says. That's what. Oh, okay. I just hadn't lost it again. That's the way that works. It's what the law says. We going by. Oh, okay, there it is. We also have this axiom, what we refer to as, if it is not prohibited, it is authorized. Google that. If there is no law that's saying that a person cannot do an act, then it is lawful. Does that make sense? If it is prohibited by law, then, if you violate or do an act, then you can, if it's against the law, then you can be civilly or criminally charged for whatever the violation is. But I guess I've made my point. So I'm hoping that the constitutional scholar and lawyer for President Trump that's going to today argue the argument, the legal theory regarding the high crimes and misdemeanor, make very clear to you, we are not and cannot and will not go on what the framers said. The framers don't live today. The framers were not bound, handcuffed, and to anchored to what they even if they were still alive, they just like Obama and any other living president, any other person that had anything to do with amending the United States Constitution or drafting bills, what they mind said, don't matter. Once it becomes the law, if that's the law, you might not didn't intend for that to be the result, but that's why we got a remedy. If that's not the result, then if a court construes and applies a law a certain way that the members that legislature Congress did not intend, their remedy is to go back and amend the law, change it. But for right now, it is what it is. So that's all I really need to say. So I guess let me make it very clear. Summarize. I'm making it very clear that it does not matter what the framers said. It's good to know, have some insight, because we were not around, get a informed understanding of what was going on, how all this came about. But what we are concerned about is what the law expressly states. A person, for example, do something, and then the courts, a judge, Congress come in and tell us something totally different than what we'll read or what we have read. The transcript says one thing, and yet here's Jerry Nadler and Adam Schiff and Nancy Pelosi telling us what the transcript meant. This though, we can only go by what we see. Okay, they don't have authority to come in and interpret what they say it means, because they lying. And whether they lying or telling the truth, does not matter. We can only go by what is written. And I wish, and from this day forward, people, we need to put our foot down, because don't wait till you become a victim or something to the IRS provision law state one thing, and then they come after you and doing this, but it meant something else. That's the problem. You're a due process, because you need to know at the time that you act or not act what you can and cannot do. That you don't need anything. We don't need things working. We relying on what we do. Man, look, y'all, we ain't doing all that. I guess I'm not as great as I would like to be, because I make videos, and it's like, people won't not taking action. Well, that day, how in the hell you gonna think it act as what I'm saying does not make sense? I'm making very clear. Put yourself in the president's shoes. If this was unlawful, he needs to know before he does this, that he can't do this. You don't sit back and let this man, and then here come a dude he get on with. If he can't do it, he needs to know. It's called a men's right. Before I do an act, if I cannot drive into this driveway because I'm not the owner of the property and I commit a crime, I need to know in advance. So should I do it? Then I intentionally did it. You knew you couldn't do it, but you done it anyway. So I can only go on. That's why I'm being protected. That's what due process does. It protects us from conduct. So again, damn what John Hamilton and James Madison, damn what they said. We only, our Constitution is the supreme law of the land, not James Madison and James Hamilton or John Hamilton. They dead. And even if they were alive, they could not override what the supreme law of the land state. The supreme law of the land. The supreme law of the land. Damn what man say. We're going on what the comes. That's why we call it a republic form of government. We got our laws. We are governed by that. Otherwise, any man can be a woman above the law because they say, well, it didn't mean that. It means what it said. If it did, if the Constitution said, like for example, the Constitution says, and I'm out of here, Section 2, Clause 8, I believe that the president and all civil officers shall be removed. Now we know that it doesn't mean that just because the president is being impeached, all other civil officers shall be impeached with him for his or her conduct, the president's conduct. So we know it doesn't mean that, but that's what it says. So I don't want to contradict myself here. So hopefully, maybe I was reading in haste, read quickly. But if it does say the president, upon conviction, the president, so the conjunction, which would be the disjunctive, or the president or any of the civil officers upon conviction shall be removed. So the Constitution might need to be amended to strike out the word conjunction and a part of speech and put in the disjunctive, or upon conviction, either the president or any civil officer of the United States upon conviction shall be removed. That would be the case. So I need to meditate upon that. I hope I haven't contradicted my whole argument here today. But, you know, because surely the civil officers, other members of Congress cannot be removed for the conduct of the President of the United States. And if I'm not mistaken, I'm thinking that's what I read. And so, conjunction and the Constitution ought to be amended, should be amended, to take out the word and, so there'll be no ambiguity here. So, but in any event, what is clear is that the President of the United States can only be removed from office for high crimes and misdemeanors, and that provision is clear.